Well, hello everybody and welcome to another of Napthan's Brief Conversations. My name is Kathryn Harwood. I'm a solicitor in the private client department, where I spend much of my time advising clients in respect of their wills and their estate planning. And I'm joined today by my fellow partner, Helen Lucking. Now, Helen heads up our family team and she spends a lot of her time advising clients when relationships break down, and notably in respect of divorce. But increasingly, Helen, we're finding ourselves working together, aren't we? Not when things go wrong, but when couples are actually planning, embarking on their married life together.
Yes, that's right, Kathryn. I think in those situations, we've had a number of occasions where you've had a client who's come to you for a will and has said to you, "Oh, I need to do something about my will, Kathryn, because I'm getting married." For a second time often, and that then rings bells for you to bring in me to talk to them about protecting the assets that they've got already before they get married. And that involves me doing either a pre-nuptial agreement for a client if they're going to get married, or a cohabitation agreement if you've got couples who are intending to live together. And that's been very interesting, and it's been a relatively recent development in prenuptial agreements. It's happened, I would say, largely over the past 10, 15 years, because there was a very famous case in 2010 called Radmacher and Granatino, and that case resulted in prenuptial agreements being more used, more relevant, and just developed in more cases, because in that case, the court said that a prenuptial agreement was valid and would be upheld. So since then, prenuptial agreements have been used in more and more cases. And whilst prenuptial agreements in themselves are not actually legally enforceable, if a couple were to have a prenuptial agreement and then get divorced, the prenup is one of the things that the court would take into account at the end of the case when deciding how to deal with a party's assets. So essentially what you're doing with a prenuptial agreement is you're deciding what would happen should you get divorced, but before you get married. And that is a very unromantic notion. But if you've been married before, or if you have got quite a substantial amount of money, whether it's savings or inheritance, a prenuptial agreement suddenly becomes something that's perhaps necessary and very attractive, and it's part of somebody's overall financial planning. So suddenly prenuptial agreements, as I said, whilst not romantic, are something that people really do need to consider. And as I often say to clients, they're not just for footballers. If you have any amount of money, if you've got a property, or as I say, you've inherited some wealth, or you might even want to protect future wealth that you know you're going to come into in the future, that might be a case for doing a prenuptial agreement.
And I think we do see, Helen, don't we, actually, that now it's the second time around us. So those perhaps more mature couples who, have amassed wealth during their lifetimes, and they're looking not only at their own situation, but they are thinking that they've got children as well who they're wanting to look after their future interests. But also we've got younger couples too, whereas I think now it's all about the bank of mum and dad, isn't it? That parents are helping children get onto the property ladder and so forth. And I think those parents are very keen, aren't they, that their children should do something at least to protect those gifts, that inheritance, if you will, in those early years of a marriage.
Absolutely, because it's often quite substantial, because property prices are high. And if a young couple haven't got the deposit together, it could easily be a hefty sum of, £50,000 that's put down as a deposit. But essentially, if the marriage were to break down in a short period of time and that money is not protected, then the other party is going to be entitled to a share upon a divorce. So exactly, that's the kind of thing that you would want to protect by way of a prenup. And it's very important that there are a series of steps that you need to take, both parties need to take, before a prenup is actually signed, because you need to make sure that each party takes independent legal advice, that there isn't any duress when you sign a prenup, that the terms of the prenup are actually fair, and that it's signed within 28 days, usually before the wedding. And also there has to be financial disclosure. So you can't have a prenuptial agreement where the husband or the wife, the other party, doesn't know what assets there are. The whole point is that there has to be open disclosure so that you're going into the marriage, as you should, knowing what the other person has. And then a prenup actually then says, right, okay, well, I've got these assets, you've got these assets, they're on a schedule at the end of the prenup. And then you have in the actual prenup itself some clauses that say, if we were to split up, then this is what will happen in the divorce proceedings. And it gives parties an element of control. I suppose in the same way as you could say when you're doing a will, because one of the clauses that's in the prenup is often a clause that says that the prenup will mirror a will that a party might make, because of course you might have a prenup and then somebody might die. So rather than a prenup and then get divorced. So in those cases, it's important that you and I work together, isn't it? And make sure that the wills are drafted in the same kind of terms.
Absolutely. Yeah, I mean, and that is, as you say, why quite often what will happen is that someone will come to me for the will and it ends up referring into a prenup and vice versa. But I mean, again, a will doesn't sound terribly romantic, does it? You know, you'd far rather be thinking about wedding breakfast and floral arrangements. But I mean, what I've noticed over the years is that something that very many people don't realise is that a marriage will automatically revoke any will that either party to that marriage has put in place. And it doesn't matter whether actually what they would want is exactly the same to continue. They will become intestate when they marry, unless they have made a will which is expressly made as being in anticipation of that specific wedding. And if they do that, then its terms will hold good. So couples do have that lead up to the marriage to work on the prenup and the will, make sure that they marry each other, if you will, in terms of what they provide, and that the right steps are in place. Because obviously marriage, it's a huge thing, isn't it? And it does change in legal terms very much the way in which your assets will be dealt with, not only if you split up, but also if you die. And you know, it may be that a couple have decided that they're of independent wealth, that actually there's no need for them to make any provision for each other. But if they don't make a new will in anticipation of that marriage, or very shortly thereafter, their new spouse will acquire the rights on intestacy, which might mean in some circumstances that they will inherit the whole estate, or at least part of it. And equally, it might be that a couple are marrying and they would very much want to make some provision for each other, that maybe they're quite a wealthy couple, they have significant assets, and that the intestacy provisions which would apply would not be sufficient to enable their surviving widow or widower to maintain the lifestyle to which they have been accustomed. And that could then lead to a claim against the estate. And where we're looking at spousal claims under the Inheritance Provision for Family Independence Act, then we are looking at the spouse being in a similar position to that which they could have expected to have been in had they divorced, which again brings us back to the prenup, doesn't it? And what you are agreeing there that you are going to do. So it's very much a conversation between two people and agreeing the way forward whilst they are on good terms, and hopefully will remain so, and a joint plan, isn't it?
It, very much so. And I think that's another factor, is that these conversations can be very awkward. And I think for that reason, perhaps people don't have them early enough. And it would be much better to have those conversations about a prenup and about a will, and make the will in contemplation of the marriage, you know, 6 months before they get married, even 12 months before they get married, because in that situation, you're then dealing with it. You're getting the elephant in the room out of the way, and you can then concentrate on all the good things. And I have had experience where a relatively young couple had to do a prenup because the lady had inherited quite a lot of wealth in very sad circumstances, and she didn't really want it at the start of the marriage to go to her new husband. And it created such terrible tension for them. I mean, so we did it as quickly as we possibly could. And then there was this massive relief, because then they could get on with all the good bits of looking forward and dealing with their marriage. But I think it's important also to say that prenuptial agreements, I think I've said already, aren't legally enforceable. So they are just one of the factors that are taken into account in the circumstances of the case. But also, and I think this is particularly the case if you're a younger couple and you have a prenup, that the longer your marriage, the less weight evidentially the court places upon the prenuptial agreement. So for example, if you're a young couple that we talked about and one of you's been given a deposit by the parents, so that's the reason that you've got the prenup, you then go on and you have children together. And if you don't review the clauses in the prenup, as you become more, your marriage becomes a longer marriage, the prenup becomes of less weight and it matters less in the marriage. And certainly past about 10 years of marriage, it's really not going to hold the same evidential weight as it does in the earlier years of the marriage. But statistically, if your marriage is going to break down, it breaks down more in the earlier years, in the 10 years and under category, rather than in the sort of the longer marriages. Although obviously, sadly, those marriages do break down also. And I think when you're having the older couple as well, in that situation, hopefully if they've made wills which are sensible and reflect the terms of the prenup, hopefully the will and hopefully the prenup would then stand up for however long it is that they are together. But sometimes, Kathryn, couples ask me about, well, instead of doing a prenup, can't we just put it in a trust? And what's the answer in that situation?
Yeah, well, trusts are a funny one, I mean, as you know, Helen, we've worked together for many years, you and I am passionate about trusts.
You are.
and the role which they can play for families' estate planning. But they're not really going to be the answer in this scenario. I mean, if you transfer your assets into a trust of which you are the only beneficiary, then that's what we call a bare trust, and it's completely transparent. So the assets might be held in the name of somebody else, but for all intents and purposes, within a divorce scenario, as in any other scenario, they are yours and they will be regarded as being yours. If you transfer your assets into a genuine trust of which you and other people, so maybe your children from a previous relationship, are all included as beneficiaries, that is a genuine trust. But first of all, for tax purposes, it's what we call a chargeable lifetime transfer, which means that if the value you put in is more than the inheritance tax nil rate bound of £325,000, there will be an immediate inheritance tax charge to pay of 20% of everything over and above that amount. So that generally puts people off to begin with. And quite apart from that, I mean, as we know, Helen, from past experience, wherever people are putting assets in trust as a means of obscuring the truth, defeating creditors, defeating the claims which other people might have on their assets, there is legislation which can set those trusts aside. And even if it is a perfectly genuine arrangement and the courts accept it as such, then a judge in a divorce case might say, well, okay, I can't interfere with that trust. I can't tell those trustees what to do. But if, in my view, actually, this particular lady or this particular man is going to benefit from everything in that trust, I will deal with the matrimonial assets over which I do have jurisdiction, as though that's factored in, that's what they're going to get. So
yeah, right.
It's not really going to be an answer. And unfortunately, it does tend to be the one that comes up where the client who comes to see us isn't too keen on the full disclosure, doesn't it? That's
right. That's right. And it's very true that if you dispose of your assets into a trust or give them to another member of your family in order to avoid your spouse having them, then the court has the power to just move them back again and treat them as if they're part of the assets. So it's just, it's a pointless exercise. And we always advise clients that you just have to give, as you should, full and frank financial disclosure, and you've got to just be open and honest. So as we've said, the best way to deal with that is to come and talk to lawyers, isn't it? To come and talk to us.
Yeah.
We're not that scary, I don't think, really. Come and talk to us, and we'll help you to either do a prenuptial agreement and a will, or a cohabitation agreement if you don't intend to get married, but you still want to make those provisions. And a cohabitation agreement coupled with a will protect your assets and protect also your children. If you've got children, you're in that position. Yes.
Yeah, absolutely. I think in summary, Helen, I mean, the answer is clearly getting married. Hopefully it's a wonderful thing, and everything will work out wonderfully and you'll have a very loving life together. But if you do have assets which are inherited or which you have acquired during your lifetime, it is worth just taking some time to take some advice and working out what might be the best way forward in terms of protecting you, protecting your children, but in a way which is fair to all concerned. And that's what we're looking to help people with, isn't it?
Absolutely. Yes, you're absolutely right. Great. Thank you, Kathryn.
Okay, well, I mean, I think that's about it in summary, really. I mean, Helen and I, we both love to talk, as you've probably gathered, and so allow plenty of time if you come to see either one of us, and we'll be very happy to, to offer advice specific to your circumstances. But in essence, that's what it's all about, protecting your assets when you're looking at getting married. And thank you very much for your time, and goodbye.
Bye.